Welcome. Today, we are diving deep into the foundational conflict at the very heart of how we understand and apply the United States Constitution. Now, this isn't just a dry legal exercise. It's about the soul of a nation's ongoing argument with itself. It's a debate that stretches all the way from the ink on the founders' quills to the highest court in the land today. So, how do we stay faithful to a document written in a world of muskets and horse-drawn carriages when we're living in a world of artificial intelligence and space exploration? That is the central question we're going to unpack together. Okay, here's how we're going to tackle this. Our journey is set up as a dialectic. Think of it as a structured conversation, a clash between two powerful opposing ideas. We'll start by laying out the ground rules, the very field on which this battle is fought. Then, we'll carefully build the intellectual case for the late Chief Justice William Rehnquist and his powerful argument against a so-called living constitution. After that, we're going to put his argument to the test, see if it holds up. And finally, we'll bring in the brilliant philosophical counter-argument from Ronald Dworkin, who offers a totally different yet compelling way to be faithful to this foundational text. So before we can really understand the fight, we have to get a feel for the arena itself. The whole business of constitutional interpretation doesn't just happen in a vacuum, right? It's born from a very specific and very human place: disagreement. Disagreement over what the government should be allowed to do and, maybe more importantly, what it shouldn't. This is the seed. It's the starting point from which all of constitutional law grows. Now, what's so fascinating here is that pretty much everyone involved in this debate supposedly starts from the same place. They share three bedrock assumptions. First, that the Constitution puts up a fence. It limits what the government can do. Second, that we can actually find that fence. It's not some invisible, unknowable thing. And third, that we all basically agree this fence is a good thing, that it serves some higher purpose. So the huge, passionate, centuries-long debate isn't about if the fence exists. It's about exactly where the line is drawn, what the fence is made of, and who gets to hold the key to the gate. This brings us to the first major fault line, a real split in thinking. Is the Constitution basically just a rule book for a game? Is it mostly about process? You know, how a bill becomes a law, how we elect a president, the proper steps for a fair trial? Or is it something more? Does it also draw hard lines in the sand about the outcomes themselves? Does it say, look, there are just some things government cannot do, period, no matter how perfectly it follows the procedure? All right, so the next big question is, who's the ultimate referee? Is the power to say what the Constitution means exclusively given to the judiciary, you know, the 9 justices in their black robes? Or is this so much bigger conversation? Is it a responsibility that's shared between Congress, the president, the states, and maybe, just maybe, we the people? In other words, who really gets the final say? And that brings us right to the heart of the matter, the central battleground for our explainer today. Where do we even look for meaning? Is the Constitution like a time capsule, its meaning permanently sealed by what the guys who wrote it in the 18th century were thinking? Or is it more like a living tree, something that draws its meaning from big, abstract principles that can be applied to our world, allowing it to grow and adapt to new challenges and new understandings? You know, this whole debate isn't just some academic thought exercise. It exploded into a political firestorm thanks to the Supreme Court under Chief Justice Earl Warren. From desegregating schools and Brown v. Board of Education to completely reshaping criminal justice and voting rights, the Warren Court issued a series of earth-shattering decisions. For supporters, this was heroic stuff, long overdue justice. But for critics, it was a shocking abuse of judicial power. That era, it was the earthquake that created the intellectual fault lines we are still dealing with today. This table does a fantastic job of laying out the intellectual landscape that came out of that earthquake. See, the Warren Court insisted that its transformative decisions were, in fact, faithful to the Constitution. So you get 3 different reactions. First, there's William Rehnquist. He didn't like the decisions, and he flat out rejected the claim that they were faithful. For him, it was bad policy and bad law. Then you've got the living Constitution liberal. They loved the decisions, but they kind of agreed with Rehnquist that the court was making new law to fit modern times. They just thought that was a good thing. And then you have Ronald Dworkin in a category all his own. He loved the decisions, and he completely agreed with the court's claim of fidelity. He argued that these seemingly radical changes were actually the most faithful way to interpret the Constitution. Okay, let's really dig in and build the argument of Justice William Rehnquist. To get where he's coming from, you have to see his position as a defense. He's not just defending a legal method, he's defending a very specific vision of American democracy, a vision where the will of the majority, expressed through its elected officials, is king. Rehnquist takes direct aim at this really popular idea of a living constitution. This is the view that broad phrases like equal protection are basically invitations for every new generation of judges to update the document to save us all from the dead hand of the past. Rehnquist looks at this and sees something very different. He doesn't see a rescue. He sees a hostile takeover of democratic power by a handful of unelected judges. Now, Rehnquist was no simple thinker. He tries to draw a very careful line here. He admits that some evolution is okay. Applying a principle like equal protection to something the framers never dreamed of, like the internet, that's fine, but only if that application is genuinely tied to their original intent. What's not okay, what's unacceptable, is when judges see a social problem, notice that Congress isn't doing anything about it, and decide, well, I guess it's up to us. For Rehnquist, that's the moment a judge stops being a judge and becomes a super legislator. This brings us to a really powerful metaphor for his view. For Rehnquist, the Constitution is like the last will and testament of the founding generation. A judge's job is not to guess what the deceased would have wanted today. It's not to say, well, they left their heir a horse and buggy, but what they really meant was their Tesla. Nope. The job is to read the document and figure out exactly what the words meant and what the person who wrote the will intended at the very moment it was signed. That meaning is fixed. It's frozen in the past. Okay, but any strong argument has to be able to stand up to some serious pressure. So now we're going to put on our critical thinking hats and really examine the foundations of Rehnquist's doctrine. Does the evidence he presents actually back up his claims? Are his philosophical assumptions solid all the way down? Let's deconstruct the argument. To prove how dangerous it is when judges start acting like problem solvers, Rehnquist points to two of the most infamous, most morally bankrupt decisions in the history of the Supreme Court: Dred Scott, which declared that African Americans could never be citizens, and Lochner, which struck down worker protections in the name of a so-called liberty of contract. And right here, this is where we see a central weakness in his historical argument. It's brilliant, actually. Rehnquist holds up these two cases as examples of courts just making things up, totally untethered from the Constitution. But if you go back and actually read the decisions, you find the exact opposite. The Dred Scott court bent over backwards to ground its horrific conclusion in the constitutional text and what it claimed was the framers' original racist intent. The Lochner court explicitly based its entire decision on its interpretation of the word liberty in the 14th Amendment. So his prime examples of judicial activism are ironically perfect examples of courts claiming to do exactly what he says they should do: stick to the text and original intent. This leads to a really sharp question. If Rehnquist wanted to find examples of a court stepping in because the legislature wasn't acting, why didn't he pick Brown v. Board of Education? That seems like a perfect fit. Well, the source material speculates that this was a very clever rhetorical strategy. By linking his opponent's views with the morally disgusting outcomes of Dred Scott and Lochner, he gets to put his own position on the side of the angels without ever having to engage with the more popular and more difficult Warren Court cases. What this reveals is a subtle but absolutely crucial pivot in his argument. The source argues that Rehnquist is basically forced to move the goalposts. He can't really find a single case where a court just completely ignores the words of the Constitution, so the debate shifts. His real test for whether a decision is legitimate isn't about being faithful to the text on the page. It's about being faithful to something much slipperier, much harder to pin down: the specific, concrete thoughts that were inside the heads of a group of men over 200 years ago. So when you boil it all down, Rehnquist's case rests on three main pillars, and the source we're looking at argues that each one has a serious crack in its foundation. First, his claim about the nature of the Constitution just assumes his conclusion from the start. Second, his historical argument from disastrous experiences totally backfires on him. And third, and this is the real core of it, his entire argument is built on a philosophy of deep moral skepticism. This quote, this gets to the absolute core of William Rehnquist's worldview. He's a moral skeptic. What he's saying is that at the end of the day, your claims about justice or fairness are just your personal preferences. It's like you prefer chocolate and I prefer vanilla. There's no objective truth to it. The only thing that can transform your personal moral belief into a rule that everyone has to follow is the fact of its enactment, the moment a majority of people vote for it and make it law. And this, according to our source, is where a massive contradiction appears. If he genuinely believes that no moral value has any claim on us unless a majority has voted for it, then what about his own core value, his passionate belief in majoritarian democracy? Where was that enacted? He holds it up as this objective, superior good, but by his own rules, it's just his personal preference, no better or worse than any other. He assumes the absolute truth of his own supreme value.
while at the same time denying that any objective moral truth can even exist.
Okay, so in total opposition to Rehnquist's moral skepticism, let's bring in the philosopher Ronald Dworkin. He's going to offer us a radically different way of thinking about what it means to be faithful to the Constitution. Dworkin's entire argument, and this is so important, it all hinges on this powerful philosophical distinction he makes. The difference between a concept and a conception. A concept is the big, general, abstract idea, like the concept of fairness or equality. A conception is a specific, concrete understanding of that idea. So my personal list of rules for how to divide a pizza fairly, that's my conception of the abstract concept of fairness. Rehnquist thinks the framers wrote their specific conceptions into law. Dworkin argues they wrote the big, general concepts themselves into law.
He makes this so clear with a simple but really profound thought experiment. Imagine a father telling his children, treat others fairly. Now, he has some specific examples in his own mind, of course, but he expects them to take that principle and apply it to situations he can't even imagine. And here's the key part. He is open to being corrected. If one of his kids can convince him that something he thought was fair was actually unfair, he wouldn't say, "You're violating my instructions." He'd say, "You're right. My original instruction to be fair actually demands this new, better understanding." He wants them to be guided by the grand concept of fairness itself, not just by his limited personal list of rules.
And this thought experiment just brilliantly highlights what's really at stake in this whole debate. What's the true goal of the instruction? If the father intended the broad concept of fairness, then what he really cares about is the moral character of his children. He wants them to grow up to be genuinely fair people. But if all he meant was, just follow my specific list of rules, no questions asked, then his primary interest isn't fairness at all. It's his own personal authority.
This gives us Dworkin's powerful counter-metaphor. The Constitution isn't a static, dusty old will. It's a dynamic founding charter. Imagine a scientific foundation was set up back in the 18th century with a simple mission, to advance human knowledge. Would we say that today's scientists are being unfaithful because they're using electron microscopes instead of the founders' primitive tools? Of course not. They are being faithful to the mission by using the best tools available to them today. For Dworkin, we are entrusted to use our best moral and philosophical understanding, our best tools, to pursue the Constitution's great principles.
Now, what Dworkin is arguing for here doesn't just offer a different legal interpretation. It fundamentally changes the job description of a judge. It leads to a pretty radical conclusion about what constitutional law even is. Dworkin is calling for nothing less than a fusion of constitutional law and moral philosophy. His logic is simple. If the Constitution's most important promises, phrases like equal protection of the laws or due process of law, are written as abstract moral concepts, then a judge can't be faithful to them by just acting like a historian digging for old facts. To answer the question, what does equal protection demand of us today, a judge has no choice but to engage in a tough, rigorous, philosophical inquiry into the best possible understanding of equality itself.
This leads to what Dworkin calls the principle of interpreting the Constitution in its best light. A real commitment to being faithful, he says, means you don't read the document in a way that makes it seem unjust or self-contradictory. You read it to make it the best it can be. Just like that good father in the thought experiment is interested in true fairness, a faithful interpreter should read the Constitution in a way that fulfills its highest moral aspirations and makes it the best, most just charter for the nation that it can possibly be.
And listen, this isn't some new, radical idea he just invented. As the source material points out, this principle of charitable interpretation is ancient. It goes all the way back to Plato's Apology. When the oracle at Delphi tells Socrates that no man is wiser than him, Socrates is totally baffled. He knows he's not that wise. But instead of just saying, well, the god must be a liar, he assumes the god must be telling the truth and sets out on a quest to find the deeper meaning that would make the statement true. It's the exact same intellectual move. We should approach the Constitution assuming it is wise and just, and our job is to find the interpretation that best reflects that wisdom and justice.
So, this brings our great debate to its conclusion. And what we're left with are two profoundly different visions of the Constitution. This isn't just a choice about legal methods, it's a choice about the fundamental identity and the entire purpose of the document that governs our nation.
And here it is, the final stark comparison. On one side, you have Rehnquist's view, the Constitution as a code. The source of meaning is historical. It's the specific thoughts of the framers. The judge's role is that of an archaeologist, carefully digging up that fixed original meaning. Fidelity means strictly following the founders' rules, and we the people are forever bound by their authority. On the other side, you have Dworkin's view,
the Constitution as a charter. Here, the source of meaning is found in the abstract moral concepts written right into the text. The judge's role is that of a philosopher, constantly seeking the best understanding of those principles. Fidelity is an aspiration. It's about helping the nation live up to its highest ideals. And we, the people, are not bound, but entrusted with the ongoing project of making our nation better.
And so we end with the fundamental question: which vision, which form of fidelity does a constitutional democracy like ours truly demand? Your answer to that question determines everything. It determines whether the Constitution acts mainly as an anchor, holding us firmly to the fixed positions of the past, or whether it functions as a compass, always guiding us toward the ever-receding horizon of a more perfect union.